Tonight we're asking the question, is one West Michigan judge just too tough?
College students caught drinking at Grand Valley State University branded with a criminal record for life, and critics in the legal community are calling the judge out of order.
24-hour News 8's Ann Schieber investigates.
We're going to do it in two groups. There's going to be group A through H.
Welcome to Roundup Day at Ottawa County's 58th District Court. Arraignment day for mostly Grand Valley College students charged with underage drinking. Bert Quinn drove here 2.5 hours to be with his son, age 20.
He's going to plead guilty. He's going to take responsibility for his actions. He'll probably ask for consideration from the court for a diversion program.
Good luck, because District Judge Kenneth Post doesn't offer a diversion program for first-time offenders. Recent changes in Michigan law try to give underage drinkers a break for a first offense. First offenders can enter a diversion program, typically counseling and a promise to stay clean in exchange for wiping the criminal offense off their record. We checked and found it is widely used in other college towns. East Lansing, MSU, 931 offenders did the diversion program this year. Mount Pleasant, CMU, 327. In 2007, Kalamazoo, Western, 435. Kalamazoo Chief District Judge Richard Santoni likes the diversion program. He says it addresses a bad choice in a positive way.
We're able to provide kids with a substantial amount of alcohol education. It's part of the program. If I were to simply give a kid a fine and say, don't do this anymore, what have I taught them?
But in 58th District Court in Ottawa County, where Grand Valley is based, we could find no evidence of a diversion program. We tried under the Freedom of Information Act, even to see how many underage drinking prosecutions there have been, and we're told it would take too many resources to compile for a media request.
When we started researching this story after hearing from an angry tipster, Judge Post explained his position over the phone. He said he tried a diversion program for several months, one created by the Ottawa County Prosecutor's Office. He decided it wasn't working. Too many kids, he said, were reoffending. Evidence, he says, that if kids think they can get away with something, they'll keep doing it and perhaps graduate to even worse behavior.
Court costs are over and above the fine.
Judge Post didn't want to talk on camera, but he made his opinion known in court when Bert Quinn's son asked about the diversion program.
You may qualify for HIDA if you have no other offenses. I'm not applying HIDA, and I will not give you the diversion program. Any other questions?
No, sir.
Thank you.
Of the 85 defendants that morning, 73 pled guilty. They paid their $200 fine and left. There's no court order for counseling, and there's another consequence.
This is a criminal conviction. It's a misdemeanor like an assault and battery.
We checked where having such a criminal conviction could be a problem. It could raise a flag in the application for a professional license. It could be a problem in a tight job market where an applicant may have to admit to the criminal record on a job application.
You are a criminal for all intents and purposes.
Michigan law allows kids to get one criminal offense expunged from their record, but it requires the approval of the district judge. And according to the local prosecutor, Judge Post does not offer such deals for underage drinking. Even if these students could get the guilty pleas expunged, in Michigan, the plea will always be on the driving record, something that could affect insurance rates.
My main concern first is that the kids don't understand that this is serious.
Defense attorney Bill McNeil says he plans to appeal the next time Judge Post denies diversion for one of his clients. He admits it will be a battle because of the way the diversion statute is written.
Because it says may, that does give them discretion, but exercise that discretion on a case-by-case basis.
Since the judge has been refusing diversion, the prosecutors say more and more defendants are pleading not guilty and demanding jury trials. But Judge Post doesn't make it easy.
It's terrible. It's traumatizing. I feel like I don't have any rights.
Pleading not guilty requires at least 3 more court appearances, a $200 cash bond, an instant drug test, and restrictions on travel. Dan Beal believes the evidence in his case is slim, and trying for an acquittal is worth it.
So basically, I'd rather just go into the real world with a clean slate without having to worry about, oh, well, what's this, an MIP on your record? I don't want to hire you. And I'm like, well, what can I really say about that?
Drinking under age 21 is against the law, and binge drinking on college campuses has become a problem over the years. Counseling for offenders can be a costly headache for courts, but one worth it in the eyes of some.
We can't afford not to. We have to do this. This is part of changing behavior.
Ann Schieber, 24 Hour News 8.